Equal Education Law Centre legal researcher Katherine Sutherland joins us now to weigh in on the BELA Bill. Katherine, thank you so much for your time this afternoon. So would like to first get your reaction as Equal Education on the signing of the BELA Bill by the President today.
Thank you so much for having me. Our general reaction is that we're very happy that the bill has been signed after 10 years in development, 10 years of public consultation, of oral hearings, of public hearings, and so it's really been quite a journey. We were very bitterly disappointed that the two strongest and probably the most equitable provisions have been delayed for 3 months. And we're a bit concerned about the legality of that and the reasoning behind it. But generally, otherwise, we're very happy that the bill's been signed into law.
I'm very glad you mentioned those public hearings, Katherine, because now we understand that, of course, Clause 4 and 5 is still up for further debate or amendment should, of course, those aggrieved parties then bring viable alternatives to the President in the 3-month period stipulated. And the fact that the Basic Education Minister was clearly not present, citing her party's stance on the bill. What do you think this means then going forward for the relationship within the GNU?
I think, one of the most concerning things about this process has been, so I think first it's very important to note that the only reason the President can not sign a bill or send it back to Parliament is because of issues or concerns around the constitutionality of the bill or particular provisions. And essentially what those two provisions do in terms of giving the Provincial Education Department oversight over school language policies and school admissions policies and the power to intervene if those policies are discriminatory or inappropriate or hinder equitable access to basic education. So they try to address the school admissions crisis. They try to address the fact that we have very limited resources and these resources are being gatekept and guarded by former Model C schools that want to maintain extremely small class sizes and not accept learners, for example, who want to apply for fee exemptions or live outside of the area and can't pay fees. So, these are really important clauses. And I think key here is that they really only confirm what the courts have already said. They're not new. They legislate for what is already in the law and what in terms of judicial decision making. So the Constitutional Court and the Supreme Court of Appeal have repeatedly said that school governing bodies are not allowed to make language policies with only regard to the learners that are in their school. They have to consider things like the demand and the language needs of the surrounding community. And they've also said that in no uncertain terms, the head of department has the final decision-making power with regard to admitting a learner in a school. So concerns around the constitutionality of these provisions, I think, are incredibly unfounded, which makes one think that perhaps the reason that these provisions are being delayed is political. And that's, unfortunately not allowed and, is unconstitutional. So the threat that the DA has made that the BELA Bill holds a knife to the throat of the GNU is an incredibly irresponsible use of their power to protect a very small, very privileged minority of former Model C schools. And, is just incredibly concerning.
Katherine, let's backtrack a little bit. I mean, I'm sure you've seen there's been quite a few mixed reactions to this bill, even a lot of misinformation that has also been doing the rounds in the media as well as social media spaces. Please iron out some of these, of course, misconceptions about the bill once and for all. What would you like to clarify about the bill in its current form?
So the bill has been called an abortion bill. This claim is largely, entirely unfounded. The bill mentions nothing about abortion. In fact, it allows the minister to make regulations on learner pregnancy, which, those regulations also have to go through a public participation process. They have to, be developed in accordance with the rules of lawmaking. And the current learner pregnancy policy is about supporting learners' access to basic education when they are pregnant. So it has absolutely nothing to do with abortion. There are also concerns around the fact that the bill supposedly implements comprehensive sexual education, and the bill says absolutely nothing about this. The only way that that could be implemented is through an amendment to the CAPS curriculum, which is not currently being done. There's also concerns around the supposed centralization of decision-making powers, and as we've already spoken about, the bill doesn't take any decision-making powers away from school governing bodies. It really, as we said, confirms the role that the HOD and the Provincial Education Department have an important oversight role, but they must also act in a procedurally fair way by consulting SGBs and allowing them to appeal these decisions, and that's what the bill says about these particular dynamics and the decision-making power between these two parties.
So quite a lot of benefits in moving towards that space of equal education there, Katherine, very quickly.
Yes, absolutely. I think, we see a school admissions crisis each and every single year. Thousands of learners wait to be placed in schools well into the year. And these are, a step in the right direction to ensuring that we minimize and mitigate this crisis, especially, considering the fact that the DA-led Western Education Department has the most out-of-school learners or out-of-school children in the entire country. It's a particularly urgent crisis to deal with, and we don't think that we can afford to wait 3 months for these provisions to come into place.
Katherine, thank you so much for your contribution this afternoon. Ms. Katherine Sutherland there of Equal Education Law Centre.